A tenancy in common is the most common form of co-ownership of land. Under such co-ownership, each cotenant has a separate fractional share of the land which can be leased. In the 1988 case Carr v. Deking, the Court of Appeals of Washington considered if a tenant in common who refused to join in the other cotenant's lease could eject the lessee from the land. George and Joel Carr, father and son, owned land in Lincoln County, Washington as tenants in common. From 1974 through 1986, the Carrs leased their land to Richard Deking, pursuant to a year-to-year oral lease where the Carrs received one-third of the annual crop on the land as rent. But in 1986, Joel informed Deking that he wanted cash rent beginning with the 1987 crop year. Deking didn't agree to paying cash rent on the land and contacted George about Joel's proposal. In February 1987, George and Deking executed a written 10-year crop share lease on the land without Joel's knowledge or consent. 2 months later, Joel notified Deking that Deking's lease on the land would terminate at the end of the 1987 crop year. Deking responded that he would retain possession of the land pursuant to the written 10-year crop share lease with George. Subsequently, Joel brought an action in Superior Court for a declaration that the lease was invalid and for an order requiring Deking to vacate the land. Deking argued that he couldn't be ousted from the land and that he should be declared a tenant in common with Joel for the duration of the lease or until the land was partitioned. Both parties filed cross motions for summary judgment. The Superior Court agreed with Deking and granted his motion for summary judgment. But before judgment was entered, Joel moved to amend his complaint, seeking an order granting him one-third of the crop as rent should he agree to the lease. The court denied Joel's motion, holding that he was entitled to 1/6 of the crop. Additionally, the court ordered Joel to reimburse Deking for 1/6 of the fertilizer costs. Joel appealed the decision to the Court of Appeals.